This is a courthead appeal in the matter of Titan, Wealth Holdings Limited and others and Okunola.
Morning,
My lady. Yesterday I had got to immunity and had made 3 points, as you will recall. First, that the principle didn't cover wholly extraneous comments. Second, that it is not an immunity from contempt of court.
Sorry,
Sorry, my lord.
Just, sorry, sort of diving in
My lord, I
to
apologise.
very great substance. You've made 3 points. Immunity,
In respect of immunity,
yes.
that wholly extraneous comments are covered. Second, that it is not an immunity from contempt of court. And third, that it is not an immunity against court action against improper conduct.
It's not an immunity against court action. For what?
Against improper conduct.
Are you going to elaborate on that third
Yes.
point?
So, and at my lord's invitation, would go to the case of Munster and Lamb, to which my learned friend had equally taken you to. It's in the authorities bundle at tab 11, and picking it up at page 81. So, my lord, it's your 84. So this was the case where an advocate there was an action being taken against an advocate for something he had said, and the question was that statement actionable? And Lord Justice Fry, on page 81, comes to the conclusion that the action is not maintainable, and that's the penultimate line.
Oh, sorry, we're on.
I do apologise.
I've got various numberings. Can we do the?
Yes, so it's the
report. Am I in?
the report number 607.
Got it. Thank you. Yeah.
My lady, if you I don't want to take things too quickly, so I allow you to read it. It starts near the top with the proposition that a judge, by writing a defamatory statement falsely and maliciously without reasonable probable cause, is not rendered liable for an action. And a similar proposition is established as to witnesses. And the rationale being that it is not a desire to protect actions from being brought in cases where they ought to be maintained that has led to the adoption of the present rule, but it is the fear that if the rule were otherwise, numerous actions would be brought against persons who are merely discharging their duty. So, and it goes on, must be always borne in mind that it is intended to protect, it is not intended to protect malicious and untruthful persons, but is intended to protect persons acting bona fide, and comes to the bottom, the action is not maintainable. So if an advocate speaks in a defamatory way in court, no action in defamation can be taken against him. But what's important is to then proceed. I mean, he says again, nothing could be more inconvenient than to allow actions of this description to be brought. But then importantly, the Court of Justice has control over all proceedings before it. It has very great powers, which I need not particularly refer, with regards to witnesses, solicitors and counsel. The court can always check improper conduct. So what he's saying is, you can't have an action being brought for defamation against an advocate who speaks improperly in court. But that is not to say there can't be any consequence to such behaviour, because the court can act appropriately.
What can the court do apart from granting an injunction? I mean, let's say there has been improper conduct all mixed up with the litigation. Let's say there's been an email that says, for example, you have lied about your availability in July for a hearing, and you are completely extraneous abuse, and that is because you are, and then some of the completely extraneous abuse we looked at yesterday. What can the court do apart from granting an injunction against using such language in such communications?
Well, indeed, the court can grant an injunction, and that's
well, can it?
Well, but that's the point. But
because if there is this immunity, what is the substance of checking improper conduct? I mean, it's a lovely 19th century idea.
Well, my lord, in the same way that a contempt of court proceedings, again, if there'd been something that was just so outrageous, and they said, well, actually, we're not going to press for an injunction looking forward, we're actually going to bring committal proceedings for what the advocate had said in court, or whatever it is. That wouldn't be
I'm actually concerned about this case.
My lord, of course, what I'm trying to say is that the immunity from suit doctrine doesn't preclude an action for contempt of court. But by extension, it also doesn't preclude the court saying to a witness, because of what you've just said, you mustn't make that comment again, or communication.
But I mean, unfortunately, it's quite clear that it does preclude. It does. The issue is how far does the exclusion for extraneous comments that have nothing to do with it. We've seen the case about somebody piping up in the witness box and saying, "Oh, look, you stole my wallet." That's fine. That's nothing to do with the case, and it's severable. But what I'm concerned about is stuff that is actually the stuff of litigation. I mean, 99% of people who engage in this kind of conduct do not separate it all out and say, you stole my wallet on the bus yesterday, which has nothing to do with the litigation. They say, I'm not agreeing to what you very reasonably ask in this litigation because you are a very bad person in all these ways. And so how do you sever? And what can the court do to check improper conduct of that kind?
My lord, I have 3 points in response. The first is that a difficult task is not necessarily an impossible one, and we saw my Lord Justice Warby's comments at paragraph 77 of Iqbal in 2014, where he says that the occasion might be covered by the immunity, but not all statements made on that occasion would be. The second point, and I don't want to sort of weary the court by repetition, but even if it wasn't wholly extraneous, and obviously that wholly extraneous, there's a mounting of learning that one could talk about in respect of that aspect, and again, my Lord Justice Warby's decision in Iqbal goes to some of it. It's not an easy task necessarily to work out. Even if it weren't wholly extraneous, the rationale that such statements aren't immune from contempt of court, which is an uncontested proposition. No one disputes that proposition, that you can be subject to an action for contempt of court in respect of what you may have done, irrespective of this immunity. It doesn't cover contempt of court. By extension of that, it also doesn't cover court action within the proceedings to regulate such conduct. And that's the point that Lord Justice Fry was making on page 82.
Is there any other authority, apart from that single sentence, that's not material to the decision, for the proposition that the exceptions to the immunity, which have been recounted on countless occasions, include not only contempt of court, but other steps taken by the court at the instigation of a party to achieve the same objective.
My lord, not that I know, and I will be honest with the court, that I haven't taken a completely exhaustive check for that. I mean, what I would
It's
say...
quite a stretch, doesn't it? Because
Well,
the decision in the case was you can't sue this advocate for libel for what he said in court.
Yeah.
And I'm sure you're aware that principle has recently been reiterated by the Court of Appeal in a case called Chief Constable of Sussex Police against the CPS, against XGY 2025 EWCA Civ 1230 in October of last year. With reference to Munster and Lamb and all these cases, I don't think this question was live there, but it would be quite an extension for us to say, unnoticed since the days of Munster and Lamb, there's been this lurking extension to the exception, or lurking exception to the immunity of some ill-defined scope about based on propositions about the court's powers that were not considered necessary to elaborate on.
Well, my lord, so first, I don't think it necessarily matters whether it's at the instigation of a party or otherwise. The point is, if I were to say something outrageous in court, you would be able to say to me, my lord, that language is not acceptable. And I couldn't say, oh, well, no, but I'm immune. I'm immune. I can say whatever I like, and you can't say anything to me.
Well, the judge, if it takes place like that, the judge has power, like rising or chucking you out of court. We can do lots of things short of granting an injunction, saying, Mr. Donmal, you must never say that to me again. I'm so shaking. But the difficulty is, and I believe it is really a difficulty, is whether there is a power in the court to make an order short of an injunction or do something that interferes with the conduct of the litigation. I mean, the injunction that you're seeking is based upon the conduct interfering with the litigation. Perhaps the answer is that actually this kind of thing doesn't interfere with the litigation, and you need, not in the material way, and you need a much more granular investigation of what has occurred before you consider, because it may have to go as far as contempt. I mean, that may be the answer, that in fact what's missing here, and everybody simply really assumed that this was very bad and therefore it interfered with the conduct of the litigation, but it may or may not have done, and we don't really know. We're in no position to judge.
I mean, my lord, I don't think I disagree with you insofar as at some point the threshold becomes, is this conduct that would be amount to a contempt. Now, if it on the assumption that it was,
And this is always, I mean, just help me, because I'm afraid I'm not a contempt expert. This is a criminal contempt we're talking about.
well, it would be in the sense that it's not a contempt of a court order because there hasn't yet been a court order. So yes, but I'm using contempt within the court's jurisdiction.
Just help me, Mr. Donmal. The difference between a criminal and civil for this purpose is that if you do something, if you throw your water at me, that can only be a criminal contempt, right? But if I grant an order restraining you from throwing water at me and you do it, then it would be a civil contempt.
Yes, although it might be both in that instance.
Might be both. Okay. All right. So it's helpful for me.
But
And therefore has to be proved beyond reasonable doubt.
well, but there is obviously an intimate connection between the Connolly jurisdiction I'm talking about, we're talking about protecting the court from abuse, and criminal contempt of court offence. They come from the same wellspring to protect the court from abuse, but that's not to say that they're necessarily coextensive. And so, for example, the mens rea may not need to be established for the court to say.
That's because it's obvious in most cases. I mean, if you throw the water at me, either in breach of the injunction or without an injunction, you obviously intended to throw water at me, or maybe the glass bottle. I don't know.
Well, I mean, I think, my lord, it comes to this in my analysis. Let's say, for the purpose of argument, there has been a contempt of court, as one would define it, by way of conduct. And rather than seek committal for the same, one of the parties says, well, we just don't want that to happen again. So we just want an injunction against it. Now, under this immunity that we're talking about presently, that immunity wouldn't act, in my submission, to preclude an action for contempt, but it also wouldn't act to preclude a decision prospectively to prohibit such conduct by an order.
Don't act in contempt of court again. Of course not.
Yeah, exactly.
But
So-
you said, when I asked you how do you sever, you said there were 3 answers, and you've only so far given 2. Maybe your third one will help.
Yes, well, the third one is that in reality, in most instances, it may be that the court finds that the scenario where something is both within the litigation and therefore potentially within the doctrine, but nevertheless falls to be acted upon, wouldn't actually arise in practice, because in most scenarios, if something is actually substantively to do with the case, it's not going to amount to contempt of court. So the sort of difficulty that I'm grappling with might not actually frequently arise. The wholly extraneous, in other words, could be analysed as statements which in no way relate to the litigation and therefore could be susceptible to contempt of court. But what I would say is the following. Let's say that conduct, so against my last point, that communication was potentially within the immunity and therefore but was also contemptuous. As I say, it might be difficult to conceive of that actually arising, but let's say that did arise in the facts. In that instance, my Lord Justice Warby's point about, well, what's the relationship between the solicitor being able to go off and take an action under statutory harassment, for example? They couldn't. So in that scenario, you would be faced with conduct that is outside of any regulation at all, because the solicitors can't take an action against it because it's immune from suit. And unless I was right about the court having power by way of injunctive relief, then the court can't do anything about it either, except potentially a contempt of court action in respect of the past conduct, but not prospectively.
Why not prospectively?
Well, this is on the assumption that you don't agree with me that the court has power prospectively to say you mustn't repeat such conduct.
Well, it has surely must have power to say you can't repeat contemptuous conduct.
Yeah, my lord, and that's the only point I'm trying to make, and I
Yeah.
apologise if I'm
So,
making
so
it.
you're envisaging some conduct which falls short of contempt, but doesn't qualify, but is immune from suit by way of harassment or
Well,
otherwise.
I'm actually there envisaging conduct that is contempt, but isn't being prosecuted as such. So there has been contempt. And it's no answer to say, well, you, the solicitors, should go off and take an action against it, because they can't, because it is covered by the immunity.
But a possible answer to that, there are two possible answers to that. If the conduct amounts to, or the threatened conduct would amount to contempt. One is the Attorney General clearly has power to bring proceedings, including injunctive proceedings, to restrain a contempt. The other is that the authorities suggest, although they're mixed, and in the WFZ case, Mrs. Justice Collins Rice proceeded on the assumption that the court has power to restrain a prospective contempt of court, a threatened contempt of court, at the instance of the party whose rights are engaged. So there would be a remedy on either of those bases.
Well, indeed, and my lord, on either of those bases, and I'd add a third, the court could do so of its own
Yes.
action. On all three scenarios, the jurisdiction that the court is using in that scenario is precisely the jurisdiction that I'm saying the court has, which is to issue a prospective order restraining action that would amount to contempt under the Connolly jurisdiction to prevent abuse.
But we're faced here, sort of bring us down to earth, with conduct that is alleged to be bad and interfering with the solicitor's ability to do their job anyway, but is not said to be contempt. And my lord's, coming back to my lord's original question, where is the authority for the proposition that in a situation prima facie covered by the immunity, namely a line of correspondence about the case which is peppered with vile abuse, there is really a power to make an injunction to say you can continue to conduct this litigation, but you must not pepper your correspondence with vile abuse.
Well,
Which is what this injunction now, even in its revised form, asks for.
I mean, my lord, my submission at this stage is still going to the general question of whether an injunction to prevent abusive conduct towards solicitors by way of communication could be granted. So the power question rather than...
It seems to me obvious that it cannot be granted without a saving for the immunity. So it presumably in theory could be granted to say you must not write gratuitous emails that are wholly unrelated to the litigation and are indecent or offensive or whatever the Malicious Communications Act says. You mustn't do that. So, you know, that's not allowed. But we're concerned with a much more nuanced thing, which is whether you can write about the case and at the same time abuse them, because most of it really is like that. And that seems to me to be very difficult,
My lord, I think...
even to frame the injunction.
My lord, respectfully, I think that is a framing question rather than a power question, because the problem that you're really putting to me is it's so difficult to extract one from the other, the contemptuous conduct from the legitimate conduct. And what I suppose I'm addressing on this ground is, let's assume that we're just, the mixed question I'm going to have to deal with, but if we just have contemptuous conduct, does the immunity preclude court action? And for the reasons...
Well, we know it doesn't.
Well, then I don't need to...
If it's contemptuous.
Exactly. So, and I don't need to speak further upon it.
But here it is not said to be contemptuous. So.
But my lord, I suppose the point is it's not said to be... Obviously, we're moving on to discuss on what basis the jurisdiction could be articulated. And one of the things that I will say is, well, the Connolly jurisdiction is a jurisdiction to prevent abuse of court. So in effect, the first test is the conduct to be prohibited, and the conduct which has taken place liable to be contempt?
I know, but so far we've got, I'm afraid, we've got a single dictum from, Obiter dictum from Lord Justice Fry in 1883, which goes further than contempt, which is never...
well, respectfully, my lord, I don't think it goes further than contempt. What it's saying is that you have an immunity from suit, but you don't have an immunity from court action. And court action for contempt, and we've seen it referred to on the Iqbal authorities, court action for contempt is...
That's where we came into this. I asked you what other things the court can do apart from making orders in relation to contempt.
Well, my lord, I mean, I'm at risk of just repeating my submission. I think my answer
you
to...
carry on.
I think my answer to
Can
that
I just
would...
make one observation? You're drawing a distinction between suit and other things without telling us what you mean by suit. What we're concerned with in this case, it seems to me, is a suit. It's an action or application by a party invoking the court's power to make an order against the other party. What is that other than a suit?
Well, I suppose the distinction that I would draw is that it's not a cause of action of itself, and that's precisely the issue.
If you don't
that
have a
Mrs.
cause of
Justice-
action, you're in a better position than if you do.
Well, in this regard, yes. But the reason why it's different, my lord, is because if you have a court of action, then you're asking the court to exercise its injunction on the basis of the availability of that remedy given the cause of action. So, but we're not in that space. The jurisdictional space we're in is the jurisdiction of the court to take action to prevent abuse of its process.
Well,
So
if I can be forgiven,
yes.
one further observation.
Yes.
We've been looking at Lord Justice Fry, who gave a concurring judgment in the course of which he made some obiter observations. But if we look back at the Master of the Rolls judgment on page 79 of the bundle, there's a passage which Lord Justice Fry expressed his agreement, in which the Master of the Rolls said, no action of any kind, no criminal prosecution can be maintained against the defendant when it's established that the words complained of were uttered by him as counsel in the course of a judicial inquiry. Now, of course, we're not concerned with that particular kind of immunity, but he puts it very broadly.
yes, my lord. I mean, that's the point to which, and I apologise if I took it too quickly yesterday, but in Iqbal at
77.
yes, I'm just trying to. I think it was. Bear with me, my lord. I'm sorry, I don't have it immediately to hand. Yes, it's page 667. So it's actually the Court Appeal decision in Iqbal number 2 at tab 34. My lord, it's your page 670. I took you to this yesterday, but it's plain that the privilege does not apply to a prosecution for perjury or to contempt of
No,
court.
fine. But you're talking about something other than that. You're talking about some form of court action which is not considered to be a suit, but is not contempt or perjury or any of the established exceptions. That's the territory we're looking at.
Yes,
Yeah.
and I mean, what I would say is, let's say there had been no application, but the court has seen in the file some absolutely, not talking about the context of this case, but some absolutely outrageous communication. And the court could, of its own motion, say, I'm not having this in the context of litigation which is before me. That is abusive and completely inimical to justice, and you can't do it. And it would be no answer for the party involved to say, oh no, but I have an immunity, because the judge could say, well, you don't have an immunity from me taking action about that in the context of this proceeding. And my lord, you may not agree with me. That's
Well, it's not a question of whether I agree. I'm just trying to find the juridical basis for taking that action.
well,
The example you've given doesn't rest upon interference with the other party's conduct of the proceedings, because in that hypothesis, the court knows nothing about the impact of this material.
exactly.
It's just said that that's not the sort of thing up with which I will put.
Exactly, but my lord, to that's the point I was made yesterday, that the contempt jurisdiction is broad enough to include both authority insults and actual or risk of interference.
That's helpful, thank you.
So I mean, to put it another way, there is nothing in the authorities to suggest that the court doesn't have power to make an order precluding a repeat of statements which it feels are not to be are contemptuous of proper court process.
I mean, the problem, as I see it, is that there aren't any cases, actually, that cover our situation. So we're on new territory, and not wishing to blow our own trumpet, we're only on this new territory because we sent a note to you in October and said, we think you've missed out 3 or 4 rather important things. So there isn't a case that considers this kind of situation
No.
in the light of the immunity, in the light of Article 10, in the light of the law of contempt, and in the light of the procedural considerations. So that makes this a difficult case.
My lord, and I wouldn't in any way disagree.
And it also makes it an important case because we know, because as I said, I think yesterday, some of us have been in the law 50 years and have seen litigants in person come and go, and we know that this is not uncommon. I mean, perhaps the extent of the abuse in this case might be unusual, but it's not uncommon for litigants in person to say bad things about their opponents and their lawyers. And it's very difficult for a first instance judge to know where to go with all these rather complex concepts. And what I would be searching for is simplicity. And at the moment, the only simplicity I can imagine really is to say that this should be a very unusual order indeed. I mean, do you agree with that?
Well, I think I do, my lord. I mean, hopefully the scenario doesn't arise very often where there is language, and I'm going to come now, and I hope it's going to be helpful to some of the cases, or in particular Castley, which looks at language and contextualises it, because that, I think, may help answer the workability point, which I think is underlying my lord's concern. On what is the answer point, all I think I want to say is that immunity is not of itself the answer to whether the power exists or not. But I think I probably said all I can and maybe more on immunity. So I'm now going to turn to the third of the impediments, which was Article 10. But in so doing, I'm also going to try and assist the court on the workability question. So with that in mind, ask the court to turn to tab 51 of the authorities bundle, which starts on page 1153 or 1156.
Yes.
And you see at the head note under C that the basic facts of the case, the defendant sent an email to town councillor in which he asked, how does a councillor that has limited reading ability, profoundly deaf and partially sighted feel they can make a difference? He was charged with sending a grossly offensive electronic communication with intent to cause distress or anxiety, contrary to the Malicious Communications Act 1988, and convicted, and he appealed against that. And Lady Carr's, Lady Chief Justice, she started her discussion on page 1163 or 1166, paragraph 35. Paragraph 35 makes the point that Article 10 and the common law right of free speech effectively are coextensive. Paragraph 37, the first half of it identifies two types of speech which fall outside the scope of Article 10. The first is that it is no more than vulgar abuse and convey no ideas and no meaningful information. So that's the first type. But there's a second type, which is information ideas, which basically do carry meaningful information, but the nature of which aim at the destruction of democracy or its fundamental freedoms, and those aren't protected. So, Holocaust denial might be an example. But obviously, she goes on. The law does not require courtesy, and it is tried law that speech does not lose protection just because the information or ideas that it conveys are offensive, disturbing, or even shocking. Over the page, at 39, she addresses that second type of communication, namely, destructive of human rights principles, and concludes that it's not of that nature. And then at 40, she asks herself the other type of, is it covered at all? Does Article 10 engage at all? The 3rd of June email cannot properly be treated as a meaningless communication that contains nothing other than abuse. Now, it's possible that to understand her conclusion on that point, it might have assisted you to read the full text of the email, which is at paragraph 12. And if you want to pause to do so, but effectively she is saying that as she goes on, there's an email sent to a town council about public concerns, referring to events as a town council meeting, the problems which Middlewich was said to have, and looking to the town councillors to improve the town's residents, and the aspect of the email in question was in that context.
Which paragraph are you at?
Sorry, I was still reading paragraph 40.
40.
I'm
Yes,
so sorry.
Thank you. Yeah.
And so the question then becomes, so given that email and the sentence within it did engage Article 10, the question was whether the process of finding the sender.
Well, this
So
is very clear, isn't it?
Yes. But, my lord, sorry, I think I misheard.
I said it's very clear
Yes. What her judgment?
whether the process was compatible
Yes,
with
and she
fundamental
says
rights
it's not.
of freedom of expression.
Yeah.
It's not.
And at 44, so obviously Article 10 is qualified. At 44, Lady Carr identifies 3 types of cases derived from Supreme Court judgment in abortion services. The first is which, on a proper analysis, the applicable common criminal law doesn't interfere with fundamental rights at all. Second, those in which the criminal law does or may interfere with such rights, but proof of the ingredients of the offence will, without more, be sufficient to render a conviction proportionate. And third, those in which the law does or may interfere with fundamental rights, but the ingredients of the offence do not of themselves meet the proportionality requirement. And as you see at paragraph 46, the present case before her, so was grossly offensive sufficient to establish the proportionality exercise of itself. Her answer is it's not of the first or second category. So one has to address grossly offensive and put within that determination the human rights proportionality exercise. And so that's what we see then at paragraph 48. Whether a message is grossly offensive is a question of fact to be answered objectively by reference to its contents and context. The question is whether the message goes beyond the limits of what is tolerable in our society. The answer must reflect society's fundamental values. Obviously, both of those points, my Lord, echoed something that you raised with me yesterday about contextual understanding. And that's repeated over the page at 4. The context of the speech must be considered. And then I'd also note at 52, whether a communication is so grossly offensive that it amounts to a criminal offence and loses the protection of freedom of speech depends on its content, the context in which it was sent for the purposes of the sender. So repeating points we've just seen. But you might note 2, little 2 under 52. When people are expressing themselves in a political context, the law expects those who receive the communications to have a thicker skin than those who are ordinary citizens. And it may be that, my lords, my lady, you may feel that people who are expressing themselves in a context of litigation, those who receive the communications might have a thicker skin than in other contexts. Now, I'm not saying anything about the particular facts of this case, but that is an observation.
Well, she's very clear. The use of strong language, even that which is offensive, shocking, or extremely rude, may not be enough to amount to the offence charge.
Exactly. But at the other extreme, she's not saying that there's no language that could, in that context, amount to a criminal offence. It's just.
But doesn't that mean, as a matter of practical reality, if you're a judge hearing the sort of application that was presented here, one of the first things you've got to do is settle down and look at exactly what's on the page and decide which side of the Article 10 line it lies on, and indeed what side of the immunity line you think it lies on, because the rules might be different depending on whether it's immune or covered by Article 10 or protectionism, or whether it's outside that.
I mean, my lady, yes on the Article 2, I would say no on the immune. I would say that the immune just doesn't.
But you accept it as an alternative.
But on the Article 10, exactly. Yeah. And actually, beyond Article 10, also to the question of, is it in fact liable to be a contempt? Like if they were, is that conduct really so inimical to court proceedings that it could be a criminal contempt, if that were the issue? and that requires a contextual analysis. And I think what
Sorry, can we just go one further? So it requires a really close evaluation or analysis of what was actually said, because what you're then being asked to do as the judge is to say, because of what's gone on in the past, that you're satisfied there's a material risk of serious interference in the future. So what you're then doing is looking at the extent to which the communications which you think are, will you be influenced by the extent to which they're impermissible because they are, let's say, they are contemptuous or they're not protected by Article 10, and on one analysis they're not immune. To what extent did those in the past interfere with the course of justice? Because that's what you're really, that's the focus that you're really
yes,
pursuing,
and one of the things is that there will be easier cases and there will be more difficult cases. And when we were discussing line mile yesterday, I don't think there's any suggestion that Mr. Justice Sweeting was incorrect in law in the conclusion he reached. And the response of the court to my submissions were, well, but that was a more serious case. And I would agree with that. And so on the question, this primary question in the abstract, is there jurisdiction to make the sort of order that Mr. Justice Sweeting made? That's why I say, yes, there is. The harder question is on the facts of this case or other cases which don't reach that threshold. But that's not an answer to whether there's the jurisdiction or not.
No.
And I think the other point to make by reference to Casserly is this sort of detailed, nuanced judgment that would need to be undertaken in a case where the jurisdiction we're talking about may be at issue, and allowing for the possibility that some cases might be much clearer, but where it isn't a clear case, courts are already engaged in this sort of analysis. I mean, it's difficult analysis, but they have to do it, and Casserly is an example of that. And on that point, I would also take you just briefly to a passage cited in Iqbal number 1 from which is at tab 33, page 649. Your page 652, the House of Lords. So where the House of Lords in Mazurovsky and Guy's and St Thomas's Hospital was cited.
Which paragraph are you on?
I'm at paragraph 35.
Tab 33.
Tab 33, our authorities 649.
Yep.
And there the House of Lords was engaged in a question about vicarious liability for harassment. And the point I wanted to draw to your attention was actually over the page at the top. Courts are well able to recognise the boundary between conduct which is unattractive, even unreasonable, and conduct which is oppressive and unacceptable. And then
it's easy for the Supreme Court or the House of Lords to say,
one would hope that they've got a career of experience in the law too, which underpins that point.
It's a serious point, because my lady's approach suggests that it's really necessary to get stuck in,
my lord,
to the material and answer the question whether this is vile abuse, which is interfering with the course of justice in a meaningful way.
my lord,
Seriously.
my lord,
And actually that question might be quite difficult to answer positively, because it happens every day that Quinn and Manuel get rude letters, and they actually set up a box to isolate the rudeness, and the interference would have been modest. That they sometimes the paralegal that was assigned to look through all this stuff missed a bit that was relevant.
Well, my lord, I completely accept the point that it's difficult. The point that Baroness Hale went on to make it at 36.
Where do we find that?
Just immediately following.
Where she made it at 66.
A great deal is left to the wisdom of the courts to draw sensible lines in the nature of discussion. But the reality...
The banter and badinage of ordinary life is actually different in litigation. People become genuinely offensive in litigation, particularly litigants in person, because they feel so personally offended and affected by what is being done. This happens all day long.
My lord, that may... I don't know whether that does happen all day long or not, but let's suppose it were the case. It's not the case that there is nonetheless no limit to which the court will permit such. I mean, it's not to say, well, now it's just a free-for-all. Obviously, I would answer to that allowance can be made for context, for the nature of the litigant, for the nature of the person receiving. So if the recipient, some of these emails were sent to a female solicitor, she might be a young female solicitor of a very important company, but she nevertheless receives them. Now, the point is that there is a line, in my respectful submission, where the court could say, well, we've been quite, we accept the difficulty of the situation, we might accept a lot of things, but this has actually crossed it. And all my submission to you really is there is a line. Exactly where that line is might be difficult and contextual and everything else, but there is a line, and the criminal jurisdiction recognises there is a line, and that's to what Lady Carr talks, and it's a high line maybe, but there's a line, and so the question of whether it is workable, my answer to that is the courts do undertake the difficult task of making these distinctions in their work. And the second response is, if it says, well, we can't have the jurisdiction or exercise it because it wouldn't be workable, the corollary of that is that there is in fact no line.
So this is a sort of parry to the floodgates argument, isn't it? That we don't need to worry about these injunctions popping up everywhere because the safeguard is the system itself, is that you have sensible judges up and down the land who aren't going to be oppressed or bullied into making these injunctions, save in those few cases where they are satisfied it's necessary in the interests of justice to do so.
Exactly, and there's the case of Khan and Khan, and I don't want to delay the court by going to it, but that's a case where there's a harassment allegation in the context of litigation, and the court looks at the stuff and says, oh, no, this is the sort of material that happens in cases. No. And so it is difficult, but it doesn't...
Where do we find Khan?
At tab 39, and if we go to page 770, or your 772, sorry, I said 77, exactly, so your 773. So this was a case where an interim injunction was being sought to prevent a type of communication that was being claimed to be harassment by the claimant. And the court, Mr. Justice Nicklin, found that the claimant probably wouldn't succeed, and you see at 1, I do not consider that either individually or collectively these emails have crossed the line from unattractive, even unreasonable, to oppressive and unacceptable.
Where was that?
Sorry, it's at 75.1.
Yep.
And further, you may see at 75.2, again by way of a sort of contextual analysis. Some of the emails contain language suggestive of threats, but these threats lack clarity, consistency, and over 9 months they've never been acted upon. The underlying theme of the emails say claimants and Spotify say to the claimants and Spotify, you make this disclosure to the markets and the regulators, or I will, and so on. So again, I mean, there's a lot of points of detail, but courts are having to engage already in analysis of inter-parties correspondence and determine whether that is unacceptable or not. And my short point is that they are capable of doing so, and to conclude that they wouldn't be capable of doing so is in effect to allow that, as I say, that there would be in effect no conduct in correspondence that could give rise to court action to prevent the recurrence. On workability, I mean, it's a very minor point, but I hope not completely irrelevant. It is possibly worth noting that Mr. Justice Friedman, Mr. Justice Chamberlain, and Mrs. Justice Hill all did make injunctions in this case against the respondent, prohibiting conduct towards the claimants along the same lines.
Well, but they didn't have any of this argument.
Well, indeed, and doubtless one can pick the same holes in the terminology used in those injunctions too. My only point, my lord, is that 3 High Court judges have grappled with the issue in the context of a harassment claim and felt able to resolve it. Now, there may be problems in the way they did so, or not. But the point remains that the jurisdiction that I'm discussing here is not completely unfamiliar to courts when sitting judges will have a sense of what is going to be acceptable before them and what is...
Well, the difference, of course, is that they were operating a very well-established regime, originating in statute and covered in a wealth of authority concerning harassment outside the conduct of inter-parties correspondence. So, for my part, I have no criticism to make of the way that those points were dealt with. But this is...
Well, my lord, I think...
context.
I don't know whether it all was outside the context of inter-parties correspondence. I don't. But in any
some
case,
of it was, I think.
Yeah. The point I'm trying to make is, insofar as they were dealing with it in those statutory formulations, what we see from Casserly and what we also see from Khan and also Iqbal number 1, where they were dealing with, well, could this communication amount to harassment or not, is courts are engaging in the exercise of considering material and determining whether it's acceptable or not. And that's the only point I was sort of making. The last point I was going to make on Article 10, very briefly I hope, is on the justification side. And we have the case of Rex and Jordan in the Authorities Bundle at 52, page 1169, 1172. That this was a case where the defendant played recorded music outside a Crown Court through a megaphone. And he was summarily convicted of contempt of court. At 1174, we have a discussion of contempt in the face of the court. And you see at paragraph 23, contempt of court is the label or umbrella name for a disparate body of legal rules or principles which share the common purpose of protecting the due administration of justice. So that purpose is obviously the same as the basis for the Connolly injunction that we're discussing. The achievement of that aim is not only of interest to those directly involved in legal proceedings. Securing the efficient and fair administration of justice is intrinsic to upholding the rule of law, which is in the interest of the public generally. So this is the point that whether or not an application has been brought by a party, or whether the court's considering it of its own motion, ultimately it's not a question of the party's interest. And then at 25, it is well established that it is not necessary to prove that the course of justice was in fact impeded or prejudiced. It is enough to show that what the defendant did created a risk that this would occur. And then there's discussion of various points, including mens rea and specific intent. But sorry, I'm going too fast. At paragraph 36 begins the analysis of the seriousness of the conduct. And at 38, we agree that the law of contempt incorporates a threshold of gravity, and the threshold being a serious interference with the administration of justice. What we had on the facts of that case was a significant actual impediment, and that's the bottom of 40. And then we get into 41, the state of mind. And my lord, you've already made the point in your throwing glass of water scenario that is made at paragraph 43, which is that it would be sufficient that I intended to throw the glass of water. And then at the end of the judgment, the court answers the Article 10 and in that instance 11 complaint that freedom of speech and assembly had been breached by punishment of playing the music outside. And I'll ask you to read 72 and 73 if I may.
Yes.
So 72 is making the point that once something is a contempt of court, that by definition, any restraint on free expression is justified under Article 10(2). And the analytical explanation that follows in 73 is that it is contempt of court is of the second category of those three categories that we saw earlier discussed in Cassely, namely that once it's contempt, by baked into that notion is the fact that it can't be justified considering the right of free expression, notwithstanding.
Yeah, one mustn't press this too far, of course, because this was contempt in the face of the court. And there are other categories of contempt that may be justifiable, for instance, where the risk of prejudice is incidental to the discussion of a matter of public interest, Section 5 of the Contempt of Court Act. So this may not apply across the board.
My Lord, I defer to you on that, and I see the force of that point. I mean, obviously, if I recall correctly, that's in the context of publication. You know, so there's a statutory context there. But my Lord, yes.
Yeah, well, there was a common law background to the statutory provision, but you're right.
So that's all I wish to say on Article 10, that it doesn't exist as a to necessarily preclude the exercise of the jurisdiction we're talking about, but it must be considered. And now, excitingly, we go beyond the impediments to threshold and discretion, and my submissions on that. And I suppose I said excitingly because at this point one is in, to some degree, into new territory for me as counsel, because these are the points that haven't really been articulated in the cases, because for the reasons that we've already discussed, there aren't very many cases about the exercise of the sort of jurisdiction we're talking about. Now, I think my first point is that the threshold question is still a power issue, because in my submission, unless the threshold tests are met, there isn't the principled power to make the injunction. Then, if the threshold is met, in my submission there becomes then a discretionary question as to whether that power should be exercised. My Lord, you asked me about whether I agreed with my learned friends for tests yesterday, and I said I didn't, with respect. And one of my reservations is that I think those four tests conflate threshold and discretion, because his fourth point, balancing all the factors, amounted in effect to, if balancing all the factors you pass, then the injunction should be granted. And that, in effect, rids the court of discretion completely, just replaces discretion with a test, albeit that
But he
the
talks
fourth
about
point...
countervailing interest, doesn't he? And that's not really, this is a domestic law. Discretion, it's a power, an inherent power, and it would be for the court to take account of anything that was relevant.
Exactly. Now, I respectfully agree insofar as the fourth balancing question was a human rights balancing question that needs to be done before you have the power. Yes, I agree. But that's why I think respectfully, I would try and distinguish a threshold test to the discretion issue. And it's to threshold that I turn now. I have humbly and with a bit of trepidation also four threshold points. And I'll give them to you and then I'll go through them if I may. Mm-hmm. The first is that the conduct in question must engage the contempt of court Connolly jurisdiction, if I can put it that way. In other words,
Sorry, contempt of court Connolly jurisdiction.
so the conduct in question would found or could found a contempt of court and for that reason action to prevent a repeat can be justified on the basis of the inherent jurisdiction to prevent abuse. So the first point is a threshold about the conduct in issue.
Of nature and seriousness type thing.
Yes. The second is that there needs to be a substantial risk of such conduct in the future. Or to put it in my Lord Justice Warby's formulation, it can't be a mere timeo situation. The third is that any interference with Article 10 would have to be considered. I mean, in a sense, it follows from what I've said that once it's been considered contempt, then Article 10 is answered there. But maybe for the avoidance of doubt, to have it as a third element, that Article 10 will have had to have been considered in process.
But if it's a contempt, Article 10 is likely to be overcome.
Exactly. And so, my Lord,
So, I mean,
One
if you're
could-
putting it as high as contempt,
yes, exactly.
then really you say Article 10 is covered under your 1.
Yeah, my Lord, you're right.
But anyway.
I think maybe it should be as a subset to 1.
Yes,
Is it contempt?
yeah,
The court bearing in mind Article 10.
yes. And 4?
That the court needs to be satisfied that it is just and convenient to grant the injunction. Now, on the first, it's obviously a high threshold. It is more than the unattractive, unreasonable or aggressive conduct of litigation. I put that first test in terms of the protection of court from contemptuous conduct, because that is the test which accords to the jurisdiction giving rise to the power. The sort of injunction we're talking about, in my submission, is not an injunction to prevent statutory harassment per se. It is not an injunction to prevent malicious communication per se. It may or may not have those consequences, but the basis of the jurisdiction is to protect the integrity of the court process. And so I respectfully would say that that has to be the question to which the court turns. To the point that my learned friend made yesterday afternoon, the conduct has to be unlawful. I mean, to that extent, I suppose I would agree, insofar as one's talking about contempt of court, which is unlawful. But respectfully, I think it would be unwise to use, for example, harassment or malicious communications as the proxy at that first stage. And another reason why is because the court shouldn't be necessarily having to rule on whether the conduct in question could satisfy a distinct cause of action. So if the solicitors wanted to bring their own case if they were unsuccessful and so on. The point about there being a substantial risk, I think, is self-evident. And the just and convenient aspect is derived from Section 37 of the Senior Courts Act, but in any case, I think would arise anyway. And that's the test, in effect, which the court must have in its mind when turning to the exercise of discretion. As to whether the terms of the injunction that the court is considering are appropriate or not, respectfully, I would put that into the discretionary category rather than whether the power were suitable terms to be found exists. As to discretion, then...
Can we just pause?
Oh, of course, Madam.
Section 37 said just and convenient, and I've tracked that through.
Yes.
We were shown a case yesterday that talked about necessity, whether it's necessary. And I think the case against you is that necessity, or there was discussion of whether necessity is the test. Abasti talks about it, paragraph 165. So do you say that was not the right context and we should prefer to borrow from Section 37, just and convenient?
I think the difficulty about incorporating a test of necessity at the threshold stage is that once it's necessary, then you don't have the discretion.
Quite.
So, respectfully, I don't think that necessarily directly reads across. I think where it would read across, and this is when I'll come to it in discretion and form of the order, is that the form of the order shouldn't be more than is necessary to reach the objective sought. So, for example, one might say, well, an order prohibiting sexually abusive communications is one thing, but an order prohibiting sexually abusive and belittling communications is another, because it could just be read in other contexts as just prohibiting belittling communications. And is that really appropriate and necessary for the purpose of restraining the contemptuous future conduct that one is concerned about? So on discretion, a preliminary point is that obviously one has to be careful about suggesting, even within discretion, that there is some sort of list of issues that effectively becomes some form of test. And there's obviously a huge range of potential factual circumstances that the court may be having to consider. So what I am going to humbly mention now are possible factors that I would suggest, but by no means to be exhaustive. And there's a further preliminary observation. Precisely because by this stage the threshold test has been met, the judge, I think, would be advised to make it clear, if they didn't exercise the discretion, that didn't amount to condoning the behaviour, nor in any way sort of ruling on the party's ability to take other explore other avenues if they had concerns on their own personal bases for doing so. But as to my list then, An issue to discretion would be the degree of severity of the conduct. Now, obviously, that would have to be of severity of the conduct above the threshold we've already mentioned. But one of the things that we've been having to deal with here is that the conduct in question doesn't seem as severe as that in Lymar, for example. And that might be something that goes into the discretionary discussion if indeed the threshold were met. Second, would the judge feel that the injunctions sought or as amended be workable in terms of identifying the behaviour to be prohibited without restricting a legitimate communication or behaviour? Third, would the injunction serve a useful purpose? So, for example, if very little time was left, so in this instance, the application was made 3 weeks before trial. By the time it was heard, it was the first day of the trial, which I think was 3 days long, and no instances, I think, were relied upon beyond the 13th of August, and by this stage we were in October. And I'll come to it in due course, but it could be a legitimate factor in terms of discretion to say, well, we're almost there now. I'd only be making this injunction for the purpose of this present proceedings. I don't see it serving a useful purpose. Fourth, if the judge felt and had reason, evidenced reason to feel that the application was in some way disingenuous or was being used strategically, and I'm not saying that's the case here, but I think, my Lord, you raised the concern about, well, what point in the analysis do you work out, well, what is really the reason why this has been brought before me and so on. Now, respectfully, I don't think that should go to the power to act, but it might be relevant to the discretion. Fifth,
is slaps relevant to any of this?
Not directly. I mean, I think obviously the respondent would say yes. In the sense that I think she argued that the application and the whole proceedings, the substantive proceedings, were in order to sort of shut her down from making disclosures about the appellant company. Now, I'm probably not in the best place to make submissions to you about the detail of that. But
no, but part of the problem is that that's what underlay it, was that she said there were bad things of a sexual nature going on in the company, and this was to close her down from saying so, which could affect them economically. Yeah. So it sort of comes back to my mixed communications point. I mean, however wrong-headed that may have been, and we have no way of judging whether it's right or wrong-headed. I mean, you do say that if the injunction is being used strategically, it may be relevant.
Yeah, so I agree it may be relevant. On the facts of this case, I would really note that certainly some of the emails aren't making that allegation, and there seem to be wholly...
I mean, you don't need to persuade us that some of the emails are beyond the pale.
Indeed. And equally, the slaps allegation has been made in the context, again, of this present appeal and the submissions that the respondent has very clearly and cogently put forward to the court. And there's no reason that, there's no suggestion that those should in any way be stopped or restrained. So, but my lord, to your point, the answer is yes. It's a relevant factor that the court can consider.
5.
Are there other means by which the judge could deal with the issue and assert the court's authority? So, I basically am saying here, I would have the power here to grant an injunction against you against repeating such conduct. I'm not going to exercise it. I'm telling you now, if it repeats, then that is something that I'm going to consider doing in the future.
And sometimes there are two issues here. One is whether the court could take measures before it gets to the point where the other party thinks it appropriate to seek an injunction. So heading off the problem before it actually reaches that point. And the other, which you've just focused on, is when that application is made, whether there's something the judge can do short of granting an injunction. And I suppose that might include offering the respondent the opportunity to give undertakings of some kind, or assurances, or something short of an injunction.
My lord, indeed, I think there's probably a whole manner of things that the judge could do short of an injunction.
Yeah. There might be a way of testing, if the respondent is present or represented, whether there's a real risk of repetition or escalation or whatever it may be.
And then finally, and I appreciate this is a bit of a catch-all, but all relevant contextual factors, such as maybe any mental health aspect of the person complained of, the nature of, or whether that person is a professional lawyer or otherwise, whether the person it's reasonable to expect the person to understand the gravity of what they were doing and so on and so forth.
I mean, were any of those factors in issue here? Were mental health problems ever suggested?
I'm not. I don't know. I'm sorry. I don't think it was referred to in Mr. Justice Hill's judgment, but perhaps Mr. Loof can assist.
I can deal with it as part of my reply afterwards, if that's
Okay,
that's
thank you. Well, just tell us, because then Mr. Donmal may have something to say.
Yes, so
were they suggested?
there was a suggestion by a lawyer that was briefly instructed on behalf of Ms. Okunola as part of the contempt proceedings. She was granted time to apply for legal aid, and she did. And that lawyer put in a submission saying that she had concerns about mental health. We pointed out that by that point, Ms. Okunola had been in front of a number of High Court judges. She had made a number of submissions, and she had engaged in the litigation in a way which suggested that she was perfectly capable. And there is a finding by, I believe it is Mrs. Justice Stein, but I might be corrected if that's wrong. We can certainly find the judgment, which effectively finds that there was no concerns as far as the judiciary were concerned in relation to Ms. Okunola's mental health.
Thank you.
My lord, I've already touched on in response to my lady's question the form of the order, and respectfully suggested that it shouldn't go beyond what's necessary to reach the purpose sought. The case of Smith and Backhouse at tab 49 is a useful authority, obviously, to the question of orders and undertakings. It's at tab 49, and the background would doubtless be familiar to you. Dr. Smith brought a claim that she was subject to harassment, and that was settled with Dr. Backhouse accepting undertakings which were set out at paragraph 7, which you find on 1057 of the authorities bundle, or my lord, your 1060. And in particular, noting undertakings 1 to 3 from E to G. Mr. Justice Nicklin then refused to accept those 3 parts of the undertaking and settlement, and we see that at paragraph 13, the bottom of 1059 or 1062. In effect, considering them too broad. That's at the top of 1060. From paragraph 33 on page 1065, 1068, we have Lady Justice Asplin's discussion of the applicable principles. That at 33 was the uncontested point that the court may decline to accept undertakings, even part of the settlement agreement. And then at 34, what are the principles that should govern the extent of a settlement or undertakings? Point 1, an injunction is a discretionary remedy, should be granted where it is just to do so, and the court should be slow to make an order which it will not be willing to enforce. And immediately I realise I probably have missed something out of my list of discretionary points, because that second one should probably be added to the list. You know, in sense checking whether to exercise discretion, the court could ask itself, well, would we be willing to enforce this order? Two is that it's a contextual, factual matter. 3, the obvious point that an injunction must be expressed in unambiguous language. So the defendant knows what is to be forbidden, and recognising the point at 4, that such an injunction or undertaking is a very serious matter, breach of which can lead to fine or imprisonment. And then at 35 and 36, there is the necessity aspect as discussed by Lord Justice Leggett in Quadrilla Boland. And that's about the terms of the injunction. The terms shouldn't be wider than is necessary to do justice. In that instance, to afford effective protection to the rights of the claimant in the particular case, and in this instance, in my formulation, to afford effective protection to the authority and dignity of the court proceedings. At 38 is the converse of the point we've already seen, that's imprecise or too uncertain, is again made. And then, but importantly, possibly at 54, breadth in itself is no reason to decline to accept an undertaking. And then Lord Justice Leggett's point is reframed. So there's obviously a skilled exercise to be undertaken in terms of not having something that is broader than is necessary, but nevertheless, of itself, breadth isn't a problem, and the Court of Appeal in effect found that Mr. Justice Nicklin had erred in the conclusions that he reached on the facts of that case. So those were my submissions in general terms on the exercise of the discretion. I think that just leaves me very brief submissions to make on the relief, the facts of this particular case and the relief now being sought, unless the court is assisted by anything else on the 5 point.
Thank you.
Ultimately, I don't think it necessarily falls for the court to have to decide whether Mrs. Justice Hill should have granted the injunction or not. Respectfully, the reasons she gave for declining to do so, in particular the reliance on effectively the Siskina point, were in error of law, though perhaps understandable. But it's no part of my case, or my submissions, I have no case, but no part of my submissions to you to say that the only conclusion she could have come to reasonably was to grant the injunction, even amended temporally to the proceedings immediately before her, which is a limitation I suggest she would have been obliged to impose upon the order.
Sorry, I didn't catch her. Could you just repeat?
Oh, I'm so sorry.
What amendment?
The temporal amendment. So the extent of the order was beyond the immediate proceedings, and in effect permanent insofar as there may be any proceedings in the future.
So restrict to the instant proceedings.
Exactly. And this is a point that I'll return to in respect of the relief that is actually now sought before you, which is obviously potentially for your actual determination. On whether the power arose, I think I would respectfully submit that she could reasonably have concluded it did. She could reasonably have concluded that there were within the emailed communications aspects that were inimical to the proper conduct of proceedings and could amount to a contempt. So I say she reasonably could have considered that. She could reasonably equally have considered they didn't meet that threshold. On the second point, she reasonably could have concluded that there was a substantial risk of repetition. The Article 10 points, I'm grateful to my Lord. I just fold that into the first. So then the third question, could she reasonably have considered it just and reasonable to grant the injunction, limited temporally, as I've discussed? Yes. But I certainly wouldn't go so far as to say that when considering that discretion, if she concluded that it was available to her, that the only answer to it would have been to grant it, not least because, as I say, by that stage she was on the first day of the trial, and there may have been other means available to her to make the point that such communication should cease, insofar as it may be there is a risk of repeat. Finally, therefore, to the situation now, three brief points. Mr. Gilani's statement accepts that the first instance proceedings are substantively at an end, and there aren't any continuing proceedings at the moment on which the injunction would bite in my submission. The possibility of further action in the future would not justify the power being arising or being exercisable. In effect, because there'd be no basis for the court feeling that there was a legal process that was currently endangered. The point also takes support from my second point, which is that by now I don't think there is a substantial risk of the respondent engaging in such conduct. Since trial almost 17 months ago, there have been no similar communications, and indeed, given the communications relied upon date from August 2024 and earlier, it's longer than that. And there have obviously been opportunities for communications, and there have been communications with the court, and there's no, respectfully, there's no sufficient evidence to find a substantial risk around my submission going forward. And I said that my second point was related to the first, and it is in this way. The relief being sought has the potential of saying, well, if there was some arguable breach in 20 years' time of party undertaking as a respect of information or something, and the appellants took action at that juncture, that would be even further away. I mean, it'd be, how it could be preemptively judged that there would be a substantive risk at that juncture is even an even further stretch. Then the third point is that, and obviously there's a danger of a counsel of perfection, but nonetheless there are aspects to the third order which remain possibly problematic. The first is that I confess, myself read the generality of paragraph 1 as having been limited by paragraph 4. So if we, I think the court has, I think, been sent a copy of the clean order, that the track changed orders are in the respondent's bundle at page 8.
I don't think there is a paragraph.
Oh, sorry. So now
version.
paragraph 4 is gone. Yes,
You mean
exactly. So
three?
then we have paragraph 3, the prohibition in paragraph, which is precisely the point that my lord was making. It's quite difficult to read the track changes
Yeah.
versions. Paragraph 3, as now is, the prohibition in paragraph 1 applies until further order in relation to the present proceedings. Now, it may well be the case that my learned friend is right, that is properly read as limiting paragraph 1.
No, it should say. It should say only.
Exactly. So that's a problem number 1, and then another
That's
problem.
not good drafting. You should say in one that it should be in relation to the present proceedings.
Exactly.
Yeah.
And then the second point is picking up on, I think, an observation of my lord, that paragraph 1 seems to include within it the entirety of messages or communication rather than content thereof. And it's obviously the content, the grossly offensive or indecent content that is to be prohibited, and saying such would assist in the clarity of it. But those are very much secondary points, because obviously you have my...
Yeah, well, that's helpful.
So, my lords, my lady, unless I can assist further, there's my submission.
Well, I was just asking whether you have a submission to make on procedural issue, because the terms of this injunction rather highlight that point. It looks like an interim injunction, but it lasts until the end of the proceedings and then beyond. Now, you made the point about beyond, but what submissions do you have to make about whether it's appropriate to do this by way of Part 23, and if you do it that way, whether Section 12 of the Human Rights Act comes into play?
My lord, I have the page, and in my haste to try and move on, I should have made reference to it. Effectively, my points on this are as set out in my written submissions. I would respectfully submit that it could be sought by a Part 23 application for ancillary relief on notice, and I consider that that follows both from Human Rights Act 12(2), but also it's inherent in the concern of the Supreme Court in Wolverhampton, which is obviously a newcomer injunction, that there should be opportunity for the affected parties to know about it.
Yes.
Related to that application, and again, it's the point that I've not yet stated orally, but it would need to be evidenced, and the points that my lord made in YXB about proper witness evidence, and also about the duty of full and frank disclosure. I mean, there must be a duty of candour in these sort of scenarios. You couldn't be presenting to the court one half of the emails and not the other half, if the other half were in light language and so on. So it would have to be evidence. But I think the qualification is that there would not be any reason in principle why a court couldn't make such an application as a matter of its own motion, should the grounds appear to it, and obviously giving the respondent an opportunity to say what he or she might want to on the question. And on that point, I return, I suppose, to where I started, which is to say that the species of conduct and the species of judicial action that I'm talking about are, in a sense, of a continuum with judicial action regulating conduct within the courtroom, immediately outside the courtroom, in the ways that I've discussed.
Thank you very much.
Can I just ask one question?
Yes.
Can I just pick up on one point, please, Mr. Dunwell? Back to immunity, please.
Yes.
Just if you could clear your head
Yes,
of
yes,
the
yes.
subsequent stuff and
Yes.
head back there. Just on that point that we were looking at, that arises from Munster, I think your submission or your proposition is that the inherent power is separate from the immunity from suit and is not impinged on by the fact that some of his correspondence might be immune from defamation actions. And we have discussed in this court a different argument, which is that you might say that the inherent power effectively gives way to immunity. In other words, there is another way of looking at it, that you could say that if you're going to exercise your inherent power, it could only be to the extent that these pieces of correspondence are not immune because they're beyond the pale, let's say. The question, I think, is a simpler one. Do we need to decide that? That feels to me like a really big argument about where the inherent power meets immunity from suit and how those two reconcile. The question is this: if your threshold is contempt of court, and if that's what you're saying, you don't get off the ground unless you've got something that meets contempt of court. It doesn't really matter which of those two explanations is right, does it? Because any correspondence that amounts to a contempt of court is unlikely to be covered by immunity from suit, from defamation suit, simply because it's likely to be the sort of thing that is so extreme that it wouldn't attract the immunity anyway. So I'm just wondering if we could let that sleeping dog lie.
I think I'd respectfully say that it's still answer one.
Yeah.
The fact that it might not arise is factually, in a way, supports the answer one analysis, because
So what is answer one analysis?
the answer one analysis is that my throwing of water over Master of the Rolls, hard to actually say those words, but that would be liable to be criminal contempt. And I mean, the throwing of water, unfortunately, is not a communication. I have to have a different scenario. I've said something absolutely outrageous. That could be a criminal contempt.
Yeah.
I cannot say, you can't prosecute me for criminal contempt because I'm immune. Because the immunity doesn't extend to a contempt of court action.
Yeah.
And if that's the case, then if it's a contempt of court action, the jurisdiction to say, well, you're not to do that again, not to say that again, likewise doesn't engage the immunity, because it's court action regulating.
I think that's my lady's point.
Yeah.
I think my lady's point is, if you're right, that actually this injunction only lies if there is a contempt in there, then since the inherent immunity, the immunity does not run as far as protecting contempt, we don't need to worry about that immunity, because only a contempt is could be injuncted.
Indeed.
And I mean, that is directly the contrary to what Mr. Loof says, but it is a neat solution to the problem we face. If it's correct.
And respectfully, I'd simply say that I think in your articulation you have made the option one point. The immunity doesn't run to a contempt of court. And that was effectively what I was trying to submit.
Yeah,
it doesn't run to a contempt of court, and so it likewise doesn't run to court action to protect
From
its
a
process.
contempt.
Exactly.
Yeah. Okay. Well, I think we get the point.
Thank you.
I do. Yeah. Thank you, Mr. Dunbar. Thanks for your help. We appreciate it. We know you're here as an advocate to the court and not as a party. And Mr. Loof, that does impinge on your reply. You're not replying as if you were replying to a party.
No.
You're replying to somebody who's tried to help the court.
I quite understand. There are three issues which I wanted to come back on. The first one is I briefly want to clarify my position on stage 4 of our proposed test, the balancing exercise. And secondly, I want to deal with the issue of material impact. And so, in light of the discussions of immunity, that will come into that topic. And then finally, I want to raise the issue of seriousness, which again is interlaced with the issues that have been discussed previously.
Okay.
In relation to the balancing test, or the balancing exercise of test 4, or stage 4, the test that we proposed, I maintain that the appropriate test ultimately for when relief of this nature should be granted is when it is necessary in the interest of justice. Of course, necessary does not stand on its own. It needs to be necessary in the interest of justice. And I submit that that is the appropriate test because it follows the purpose of the jurisdiction, which is precisely to make sure that the process of the court is not interfered with. Now, what I did not mean to suggest by raising countervailing interests and rights was to suggest that Article 10, freedom of speech issues, and potential immunity concerns represent, as it were, a closed list of countervailing rights and interests that would be relevant at that stage. And just briefly to come back to an issue in relation to Section 12 of the Human Rights Act in relation to Article 10, precisely because this would not be an interim order in the sense it would be one pending ultimate resolution. The Article 10 assessment on this balancing exercise would be a substantive one in accordance with subsection 4 of Section 12 of the Human Rights Act. But there would, in my submission, then not be a need to consider subsection 3, which is solely concerned with interim orders.
So just so I understand that,
Yes.
you're saying in effect there will be a trial on the application.
Well, if there are, as part of the, when you look at the rights of freedom of expression, assuming that they are engaged, of course, on the matters we're saying, assuming that there is
Assuming you have to do that.
assuming we have to do that, the exercise would involve considering whether, as a final exercise, they are properly within the proportionality exception in paragraph 2 of Article 10.
If I could just raise this, what that means is that unusually, perhaps exceptionally, you have in effect a trial of the issue of whether there should be an injunction, permanent injunction, at the hearing of a Part 23 application.
That would be right. Yes.
That's the reason why the court doesn't have to assess, it doesn't have to apply the interim injunction test in Section 12, subsection 3.
Yes.
So by bypassing the opportunity for a trial, you bypass that threshold test. And the whole thing is done on written evidence. Just trying to get this clear. I'm not.
Yes, I mean, but it's on written evidence, and of course,
trying to understand.
Yes, I mean, but that is of course the way it is usually done. There's nothing. I mean, of course, the court has discretion.
That's the way that an interim application is usually
Yes.
dealt with, but not a trial.
Yes, no, that's right.
And except a Part 8 claim, obviously, which is usually dealt with.
Well, what I would say is obviously that it's. I would suggest that it's a more stringent test in the sense that it has to come to a final conclusion on the Article 10.
Legally, I can see that, but
Yes.
factually, there might be some other issues.
Yes,
Thank
director.
you. I just wanted to understand
Yes.
what you were saying.
Now, we came on to mental health considerations, and of course, I accept that is potentially another interest that may need to be taken into account in the balancing exercise. On that point, and I'm grateful to those behind me for reminding me. So, there was the order by Mrs. Justice Steyn that I mentioned previously. That's an order of the 7th of June, 2024, where she noted that there had been discussions, as it were, that mental health diagnoses had been raised, but she finds that there was no evidence of impairment, and so there was no reason to adjourn the proceedings that were ongoing at that stage.
Where's that order?
So we will make it available to the court afterwards. It's not in the bundle. Equally not in the bundle is the judgment of Mr. Justice Kerr activating the suspended penalty on the 12th of February 2025, where his lordship noted that the behaviour and lack of insight that he had observed in the respondent, Ms. Okunola, and I think this is, I paraphrase only slightly, but he said it was consistent with litigants he had previously encountered who had been diagnosed with mental health issues. We'll of course make these two documents available to the court if that would assist. Now, finally, then on the balancing exercise, it's of course an inherently fact-specific exercise, but I maintain that if at the end of that fact-specific exercise, the judge concludes in their assessment that an order is necessary in the interest of justice, it necessarily follows that the order ought to be made. Now, whether you call that exercise an exercise of discretion, it's certainly an order which does not seek to, certainly an exercise which does not seek to tie the hands of the individual judge in determining whether an order is appropriate in the particular facts of the case before him or her. Oh, I apologise. I'm reminded that the Kerr judgment is in the bundle. It's in the supplemental bundle at page 372. It will be 375 in the PDF. On material impact, which, as you will see, is stage 1 of the 4-part test that we proposed, there were comments made in relation to the application. I think the term was potentially being a Trojan horse to protect the solicitors, and it was also commented, I think, in the same vein, that the evidence in support of the application was all about the impact on the solicitors. As I submitted yesterday, the application was based on evidence that the abusive communications, if I can put them that way, which had occurred in the past, had already caused an interference with the process of the court. And the premise of the application, therefore, was that there was a material risk that if communications of this sort continued, there would be further such interference. And so on this, a first, or should we say fundamental question for this court is whether it accepts, as a matter of principle, that abuse of solicitors when conducting litigation, and so acting as officers of the court, can amount to an interference with the process of the court. And if, as I submit, the answer to that question is yes, the question is then, well, what evidence establishing these factual circumstances, what that would look like? And I don't want to sound glib, but the process of the court can't give evidence. And so the court would inevitably have evidence from solicitors detailing the impact of the abuse on their ability to discharge their responsibilities.
But Mr. Loof, wouldn't you need to look, in light of all that we've thought about over the last 2 days, within that batch of evidence of correspondence, some of it was perhaps a bit argumentative, but it was points relevant to the case, and that can't possibly be the subject matter of an injunction, because she's got to be able to write to your solicitors about the case, even if she doesn't put it very well or nicely. So what you're looking to do is, what the judge needs to do is work out within this mass of material the extent to which it is abusive or over the line or contemptuous, or whatever your yardstick is.
Yes.
And that was never done here. And so the finding that you've got is just a generic finding that all this stuff caused a lot of trouble, but volume in and of itself, or unpleasantness of some of those emails, isn't really, as we understand it now, part of the picture, as it shouldn't be.
Well, so as a matter of fact, the evidence that was relied upon, I haven't tabulated, and perhaps I should have, but it did not include, as it were, mixed submissions of that nature. For instance, the email that my Lord Master of the Rolls has come back to was subsequent to the application having made, and so it was never submitted as being part of the evidential basis for the relief sought. So, as a matter of fact, we certainly did not intend to rely on evidence that were on communications that were submitted. But as a matter of principle now, if a court finds the evidence sufficient to establish the interference, speculation as to the underlying motive behind the application is arguably inappropriate, because if the evidence is the evidence, then given the test that the court has set out for itself, then if it accepts the evidence, the fact that there may be other considerations in the background is neither here nor there. But coming back to
that's a very binary submission in the light of slaps. I mean, there is a great deal of relevance of the reason why applications are being made.
Can I come back to the issue of slaps when I deal with the seriousness point, if I may? But in light of Abbasi, in the same way that the trust could apply relying on the parents' petri jurisdiction to anonymize the names of the clinicians, in my submission, even if it were fair to assume that the appellants in this case were also concerned about the well-being of their solicitors, frankly, that, in my submission, is neither here nor there. The concern for the court is whether the test for the relief sought is established on the evidence as is presented. And coming back to my Lord Master of the Rolls' point in terms of giving clear guidance to any first instance judges faced with these applications, inserting that kind of speculation into the matrix, or the factual matrix that the judge would need to consider, would certainly not make that exercise any easier. Now, if we then consider Gailani 5, which is at Supplemental Bundle tab 16, and in particular then the evidence that is given in paragraphs 30 through 33, and that is from page 418 of the bundle, 421 of the PDF, the following impacts are set out. Anxiety from the abuse received from Miss Okunola resulted in reticence to engage in the inter-parties correspondence that is inherent and necessary in litigation. That's paragraph 30 and 32, subparagraph B. The need to put in place an IT framework to shield individual solicitors from abusive correspondence. That's paragraph 30 and also mentioned at paragraph 32, C, little Roman 4. There were then measures put in place to prevent Miss Okunola from accessing the offices of the solicitors. That is at paragraph 32C, little Roman 4. And also the diversion of resource, i.e. lawyer time, from progressing the litigation to taking various procedural measures to try to put an end to the abuse received. That's the whole of 32C. To which should perhaps be added the making of the application itself. Now, there was discussion as well in terms of what, short of making the application, and what the judges could do when this sort of behavior arises. Now, you will see from Mr. Gailani's evidence that this application was preceded by correspondence to the court seeking the court's intervention. At that stage, it was, of course, intervention by means of guidance, effectively letting Okunola know, Ms. Okunola know that this sort of behavior is not acceptable. And that was done in July 2024. You will find that letter within tab 17, page 468 of the bundle, 471 of the PDF. And then again, following some more informal correspondence, there was an email sent in August 2014, which is at page 525 of the bundle, 528 of the PDF. So at that stage, the sort of measures...
Just give me the other page number. What was it?
It's 528 of the PDF, 525 of the bundle. So, my lord, at that stage, all sorts of measures, all sorts of intervention could have been made or taken, short of making the type of order that was eventually sought. And this is to demonstrate that
Who is Mr. Genner?
he was the clerk to Mr. Justice Chamberlain, if I recall correctly.
Thank you. So you took lots of steps before you applied.
Yes, and so the application was, as a matter of fact, a matter of last resort. And so my submission is, I suppose, that short of physical attacks, this is what interference with the process of the court by abusing the other side's solicitors looks like. And this is what the evidence showed, and that is what Mrs. Justice Hill found. I have to take you back at 20 paragraphs 24 and 25 of her judgment.
But what do you do if you think somebody is actually suffering from whether short or long-term medical problems? Does an injunction help?
Well,
she was locked up for 6 months, and she came back and did the same. Is that right?
Well, I believe she was released from prison in May time, and no, there's no evidence on the file for the.
No, but she was released from prison, and these emails obviously were sent after she was released from prison.
My lord, no.
No?
No, the emails that were relied on for the purpose of the application were before the trial.
Yes, which was, of course, in August. I mean, in August 24, you write saying this includes 89 emails sent to me on Tuesday morning. So she was obviously out of prison, and she'd come, and the trial was in 24,
Yes.
October 24.
Yes.
So she'd been released from prison in October before something like May 24.
My lord, if I may help the chronology, the interim injunction is imposed in early March of 2024. It's breached very quickly. We have a contempt trial in June 24.
So it was before she went to prison.
Well, the penalty was suspended.
Yes. When was it implemented?
Well, it was then, that's in February 2025.
Ah, I see. So I'm a year out.
Yeah, so the chronology is that pending the trial, the emails that were then relied upon as activating, as violating the harassment had intervened, but they are, as it were, separate line of.
I think I'm still a bit confused because she goes to this injunction is sought after she's come out of prison.
My lord, no, she had not gone to prison when it sought. This application was sought in the run-up to trial. So she was subjected to a 6-month suspended penalty for the contempt at that stage.
No, the contempt related that she was penalised for related to abusing the third and fourth
Yes.
claimant. And that was the injunction you got from Mr. Justice Chamberlain, etc. It was then implemented by Mr. Justice Carr.
Yes.
I mean, let me just ask you about this timing, because if I've got it wrong, it's important. My understanding is this. On the 5th of April 24, Mr. Justice Friedman granted an interim pre-action injunction restraining harassment of the third and fourth claimants. Right?
That's right.
A harassment injunction. Then, on the 15th of April, you started these proceedings, 24.
The substantive proceedings,
Yes,
yes.
substantive proceedings. On the 21st of June 24, Mr. Justice Chamberlain imposed a 6-month prison sentence, suspended. And on the 12th of February, Mr. Justice Carr activated the prison sentence.
Yes.
And she went to prison, and we don't know when she came out, but she must have come out at some stage. And when she came out, you applied before the trial, 3 weeks before the trial, as we now know, for this different injunction to prevent her abusing the law.
Well, may I respectfully correct the timeline?
Yes.
Yes. So the interim injunction was made pre-issuing of substantive proceedings in March of 2024.
Well, it was heard by Friedman on the 5th of April.
Yes.
Right. That's
Apologies. So it was heard in April, not March 2024. But
yeah, and the proceedings were issued on the 15th of April 2024.
indeed.
Yes.
There were then further harassment, as was subsequently proved, of the third and fourth claimants,
Yes.
which were the subject of the contempt proceedings before Mr. Justice Chamberlain in June 2024.
Well, yes.
Yes.
And
At
he
which point
imposed a prison sentence.
he imposed a suspended prison sentence on condition of continued compliance with the interim injunction.
Yeah. What are you correcting? 'Cause so far
I'm
that's
correcting
what I've
because
got.
now we then have the run up to trial over the summer of
No,
2024.
no, you don't have the run up to trial over the summer of 24.
Yeah, the trial's in October 2024.
Trial is in October 24.
I see.
So the
So-
failure of this application is October 2024, at which point she's under a suspended sentence but not activated at
Indeed.
the moment.
Indeed.
And what she's doing that you complain about is not said to be a breach of the injunction that was imposed originally by Mr. Justice Friedman, because it's not directed at
Quite so.
C3 and C4,
Quite
but
so.
directed at the solicitors.
Quite so. And so I will be, as in this application was heard in the trial window, in the trial
Yeah, I
hearing
understand
window.
that. So the trial took place before and judgment was given, correct?
Before any,
In October
the judgment, I believe, is 25th of October 2024. Yes.
24.
Yes.
And the appeal was bubbling along against the refusal of the second injunction when she was sent to prison.
Yes, that's correct.
I see. Okay, sorry, I completely misunderstood.
And she was in prison. She had her 3 months in the spring, February to May of 2025.
That's right.
Yeah, okay, I get that now. So it's all after the trial. I hadn't grasped that. But yeah.
Now, so what I was saying was that the short of physical attacks, this is what abuse of solicitors leading to an interference with the course of justice looks like. And I think it follows that just because a firm of solicitors has the resources to take the protective measures that were taken in this case and absorb the associated costs, and just because the solicitors are individually able to soldier on, as it were, it does not mean that the process of the court has not been interfered with. Indeed, the operation of prospective measures, as in the IT systems and the security measures at reception, etc., the operation of such measures is, in my submission, one manifestation and indeed continuing proof of the interference complained of.
Okay, I mean, this is not a reply to the legal submissions made by the advocate to the court.
It does address the nature of the threshold test in stage one. Now, in terms of immunity, there was quite a lot of discussion about the distinction between a suit and another action. And I'm perhaps too simple in relation to this, but it seems to me the distinction is this, that no consequences are sought to be imposed with respect to the prior activity, in this case, the correspondence. And the facts of this case show that, in my submission, this concern about restraining prospective conduct is not a difficulty. Now, if we look at paragraph 116 of Mrs. Justice Hill's trial judgment, so then we need to go to tab 27 of the supplemental bundle at page 607 of the PDF. And you will see there that it is an aspect of, as I believe my Lord Master of the Rolls pointed out, an aspect of Ms. Okunola's defence to the substantive harassment claim is the sort of sexually inappropriate conduct which she has been accusing not just the claimants but the solicitors of. And as we've gone through, as is not uncommon, an interim injunction was opposed, etc., leading to the various...
Which paragraph are you looking at in her judgment?
116.
Thank you.
Now, just quickly picking up on the slap issue. At the end of paragraph 17 of Mr. Justice Chamberlain's judgment finding Ms. Okunola in contempt, that is supplemental bundle tab 24 at page 576 of the PDF. I apologise, I should take you not to that paragraph 17, but I think it's paragraph 4 of that judgment where he summarises where he sets out the terms of the interim injunction. Apologies.
This is Mr. Justice Chamberlain.
Yes, you will see that he mentions there that there were some exceptions which did not concern him at the moment. Of course, we can make the interim injunction available to the court, but maybe take it from me that one of the exceptions that was included in that order was precisely Ms. Okunola's ability to make any sort of complaint that she wanted to regulators and other enforcement agencies. And
I think that appears from the judgment, the terms of the judgment later on. It may be why you were referring to 17.
I'm grateful.
I read it, yes.
Yeah, I'm grateful. So the, as it were, slap concerns were addressed in the terms of the, as in the terms of the orders. But the point I want to make is that the messages which were then held to violate a prohibition of the interim anti-harassment order were not in any way unrelated to her defence at trial. And we were, of course, not relying on those messages that were the subject of the contempt application for the purposes of the substantive claim.
But do we have a coherent analysis of what you were relying on for the injunction application?
Yes, they were set out in the application.
Where are they in the bundle?
Supplemental tab 16 and 17.
And what are the pages?
So they commence. 16 is a statement of Mr. Gilani, and from page 413 or 416 in your bundle, he sets out the chronology of the emails relied upon, and then they are all exhibited in his exhibit, which then is found in tab 17. So it runs through to paragraph 28.
Yeah, I just need pages.
Yes, so
So
pages.
I've got the page 420 in the PDF is a list of emails in his. Actually, there's only a few emails.
So the witness statement, as I understand it, is from page 416 in your numbering to 421 in your numbering, and the emails are in exhibit YG7, which is at pages 426 through, I think, to 517.
Yeah.
While I'm on my feet, I was going to. I didn't want to interrupt.
426 to 517.
My lord.
So that's a course of conduct from June 20. Are they in chronological order?
I believe so, from June 2024 to August 2024. and I haven't had the opportunity just to raise with my learned friend one point that my Lord Justice Warby asked. He said, well, did Mr. Justice Carr rely on any of these emails in the activation in 2025? I think my learned friend may have indicated no, because they weren't directed to the third and fourth claimants. I think actually they were. I'm not saying anything turns on it, but it's a page RSUP 377, which is page 380. And
So you need to say that again. I didn't understand it. What are you answering that Lord Justice Warby asked you?
I think Lord Justice Warby asked me, didn't ask me, but asked my learned friend, when Mr. Justice Carr activated the suspended sentence because of breach, were the emails relied upon for the purposes of that activation the same emails? And my recollection is the answer is no, because they weren't sent to the third and fourth claimants. But the reality from his judgment is that they, at least in part, were, because his finding was that they were indirectly harassing, and in some cases by reference.
So the same as now relied on.
Exactly.
There's an overlap, yes.
So it was a minor correction, but I thought.
No, thank you very much.
I stand corrected. Now, where I was saying that the communications that were relied upon to found the substantive harassment claim were not the same as were relied upon in order to substantiate the harassment or the contempt allegation, which was determined by Mr. Justice Chamberlain. They were subsequent to the emails that were relied upon in the substantive claim. And so, if it were the case that no restrictions could be imposed on future communications related to litigation, then that is certainly not in the spirit of what is regularly done in anti-harassment interim injunctions. It is right, as my Lord, the Master of the Rolls, pointed out, that these arguments weren't made, but it's equally right, as my Lord Justice Warby pointed out, that this is an established jurisdiction, and of course it has a statutory basis. But if we go back to what the point of the immunity from suit is, if we go back to the judgment of Master of the Rolls Brett in Munster and Lamb, so that's at page 604 of that report, tab 11 of the authorities bundle, page 80.
Well, before we go to Munster and Lamb, how long are you going to be in reply?
I have maybe another 10 minutes.
Okay, we'll carry on then.
I'm grateful.
You okay with that?
Yeah.
Yeah. Munster and Lamb.
Yes. Page 80 of the PDF.
Mm-hmm.
Actually, I'm sorry, I'm one page out. If you go down to page 81, page 78, page 604 of the report, in the middle of that, and I believe it's the point that was made to you by my learned friend, the advocate, that the Master of the Roll says the reason for the role is, the reason for the rule, and he sets it out. And so, my submission is that in discussing immunity in this context, the principal concern must be the same. And if the court considers that this would be a development of the common law, query whether that is the case, but the fact that litigants can and regularly are restrained from making statements amounting to harassment without immunity being a consideration, it is difficult to see what the concern would be with respect to conduct which is prima facie as serious, if not more serious. And in this regard, I can merely point to the difference in the penalties or the sentences that are available for harassment under Section 2 of the Harassment Act, which is maximum of 6 years imprisonment, and the offence which we now rely on as the analogy for the communications here, malicious communications, which carries a maximum sentence of 2 years imprisonment. And so on this point of seriousness, throughout the debates yesterday and today, there has been a concern expressed about where to draw the line and whether there is a risk that a judgment signalling that this type of remedy is available will cause the courts to be overwhelmed with applications of this kind. It's also been remarked that there are vanishingly few examples of these types of applications. Now, one explanation may well be that litigants tend to channel their ire, as it were, against their opponents, not their opponents' lawyers. And the court will be aware that the reports are full of examples of contempt applications in, for instance, family proceedings or breaches of injunctions protecting one or other of the parties. Now, it is not, I think, suggested that this is a reason to restrict the scope of the contempt jurisdiction. Ms. Okunola had already been held in contempt, as we saw, for violating an injunction protecting the third and fourth appellants. And so it may well be that by the time this application was made, she had adjusted her aim.
But I don't understand that. She'd been held in contempt, but and she'd been given a suspended sentence.
Yes, penalty, but yes.
But that had not been put into effect on the grounds that she was violating it.
That's right.
So,
but she was, of course, aware that her imprisonment would have resulted from harassing the claimants, not the solicitors.
I get that, but the emails that you were relying upon were between June and August 24.
Yes.
And the decision imposing the prison sentence of Mr. Justice Chamberlain was in June. So why had you not, if there was an overlap, as you told me there were, between the 150 pages, whatever it is, of emails,
yes,
and what you relied upon to activate the prison sentence, it appears she hadn't taken any notice of the prison sentence imposed in June, carried on between June and August with the conduct that was this time against the solicitors, but overlapped, also effective against the clients. I don't really understand why you then applied for a widened injunction, but not to implement the prison sentence.
We did apply. I'll be reminded when exactly it was that we applied to implement, but there was quite a delay between the application being made and the.
No, but you had a trial.
Yes, we had a trial.
So you were. I mean, I'm just trying to get a picture of it, because you wouldn't want to put it. You might not want to put him in prison when the trial was coming up. It might be said that was a bit tough. So were you sort of grinning and bearing it and not applying to say there'd been a contempt and been a breach of the order made by Chamberlain until afterwards, or what happened?
Can I turn my back to work out what the exact date of the application was? So I'm reminded that by the time the trial came around, we had already applied for the activation of that application was made on the 9th of September.
9th of September?
Yes.
24?
Yes.
And so you did two things. And when was the application original application for this injunction?
The 18th of September.
Right, okay, that's very helpful, thank you.
Now, the point I was going to make as well in terms of why these kinds of applications have not been that frequent.
May I see both those applications, please?
Yes.
Not now, but
Yes,
maybe
we'll
you
point
send
them out,
to
and
me.
if they're not in the bundles, we will.
If they're not in the
Yes.
bundles, I think one is and one isn't.
Yes. It may also be, of course, that the unfortunately ever retreating provision of legal aid means that fewer and fewer litigants are being moderated by their own lawyers. Now, of course, we can only speculate. But in this regard, I remind the court of the test for seriousness that we have proposed, and that is that the activity sought to be prohibited constitutes the conduct element of otherwise unlawful activity. From a practical perspective, it seems to me that that is eminently workable. Now, my learned friend has posited that the unlawful activity contemplated should be limited to contempt. In my submission, that is problematic, and for the following reason.
Well, because it includes mens rea.
There is that, but there is another reason which is prior to that, and it is because conduct could only amount to contempt of court if it is sufficiently serious. And saying that something is sufficiently serious amounts to contempt, therefore merely begs the question. And so the judges would still be at a loss to see, well, how do we assess whether a particular communication in this context is sufficiently serious such that it would trigger potentially the contempt jurisdiction.
But it's a different thing. Is it in contempt sufficiently serious that it interrupts interferes with the court process, or is it just sufficiently serious that it should be marked as a contempt?
Well,
it's not the same thing.
Well, there obviously has to be, as we said, there has to be evidence that there has been an interference with the lawyers on these facts. There has to be interference with the lawyer's ability to discharge their responsibilities and their duties. That being said, there is obviously, as we said, a range of conduct. In particular, litigants in person will behave in less than courteous ways, and that, of course, can potentially have an impact on the costs that are incurred by lawyers in particular, and the sorts of activities that they need to undertake. And so we are still left with a question, well, how do you determine when such conduct trips over into conduct which could amount to contempt? And so you need some kind of reference point in order for that prior question to be determined, which is why, again, we come back to this test. We posit, well, if it is conduct which is prima facie unlawful, so harassment, for instance, or in this instance, a violation of the Malicious Communications Act, you then have a trigger for assessing whether conduct, if that is the way you want to go down, would constitute, it would be contemptuous.
But the courts are deciding every day of the week, aren't they? Whether, I mean, perhaps I exaggerate, but judges often have to think about whether something that's just happened is contempt or is not contempt.
Yes.
And they do that.
My lady.
I mean, before you even get to issues of intent and so on, they
Yes.
look at the quality of the conduct and just decide if it's the sort of thing
Yes.
that really is a contempt of court, or if it's just some of the stuff that happens in court that is below the line. Is that intrinsically difficult?
Well, it depends, my lady, because when you're the point that was made to me by my Lord, the Master of the Rolls, in terms of, well, what sort of guidance can be provided to judges assessing this? Simply saying that it must amount to contempt when you're dealing with, well, what exactly is interfering, unlawful interference? You know, what is interference with the work of lawyers that we should restrain? Well, if it would be contempt, you need to assess how serious the issue is, and so that's why I'm saying it's not necessarily helpful to say that it should amount to contempt, but because that doesn't give you a gauge as to what conduct is.
Contempt
It would
is
be
contempt
circular.
because it's contemptuous.
Exactly.
It doesn't help.
And so, in order to cut through that, my submission is that the test of conduct which amount effectively to the conduct element of unlawful activity is a clearer guide to when the power ought to be exercised.
I mean, perhaps the best analysis of contempt by people who really know are from the President of the King's Bench Division and my Lord, for it was he, at paragraph 38 in Jordan. The law of contempt incorporates a threshold of gravity, and it was described to us on this appeal. The Supreme Court says conduct which goes beyond mere non-compliance with a court order or undertaking involves a serious interference with the administration of justice, right? Which is a different formulation from the formulation of Connolly or the inherent jurisdiction to protect the integrity of the court's process in the interests of justice. It may be a similar concept. So what do you say about that? I mean, you're submitting, as I understand it, I'm sorry if we're going on longer than the 10 minutes, and you tell me if you think it's going to be a lengthy debate, but you are submitting, as I understand it, that contempt is not the yardstick for this, and should not be the yardstick, for the reasons you've given, that first of all you should exclude mens rea. It should just be to protect the court from particular conduct. But do you go so far as to say that contempt is a different concept and you must have the capacity to injunct stuff that may well not be contempt if it's interfering with the process? Then question, conduct which goes beyond mere non-compliance, not relevant to us, but involves a serious interference with the administration of justice. When will that not be what we're talking about in the case we're concerned with?
Well, precisely, that is precisely because, I mean, that's precisely the reason why we have proposed this seriousness threshold. When it would not be contempt, well, as my Lord, you posited, for instance, well, there is the issue of mens rea, which is important because
because we're not talking about throwing bottles of water around,
and also we're not talking about punishing past conduct. We're talking about preventing recurrence of future conduct.
There's a degree of artificiality about the mens rea point, may I suggest, because the reality is that you're going to court saying what's happened in the past has been a serious interference, or whatever standard you're applying, and the court is either going to accept that or not. If the court accepts that and pronounces that finding, the notion that the respondent can say, well, I could do it again, but it won't be a serious interference, or if it is, I won't be intending that, therefore the mens rea element of contempt is not present, is fanciful.
But my Lord, at that stage, it would no longer be a criminal contempt; it would be a civil contempt, because it would be a violation of the court order.
Well, perhaps, but if the injunction is seeking to prevent conduct which would, on the basis that it would amount to a criminal contempt of court by interfering with the course of justice, the notional problem that you put forward of a mens rea element being difficult to prove is I suggest fanciful, because if the court's going to answer that question, you'll be able to say, well, once we've said accepted its interference, then that's the basis for the injunction, and therefore any breach of the injunction will, as it happens, be a civil contempt as well as a criminal contempt.
I mean, potentially, but because you're looking at it from the perspective of the process of the court, the intention, as it were, is not relevant. It's neither here nor there. It's the material impact, or the factual impact on what the court is doing that matters. And so that is what the court is seeking to protect. Now, when we come to the enforcement side, if there were a further breach, then of course all kinds of considerations may come in, whether we're talking mental health issues, etc., then that can be considered whether it's appropriate to impose any kind of penalty, for instance. And it could also be taken into consideration at the point where, well, balancing all the rights and interests at stake, is this a respondent who would respond to, as in, could we, given the people that we have in front of us, expect that us making this kind of order would in fact remedy the mischief that we are seeking to prevent.
But your fundamental submission, whilst we're on this question of what you're saying about the law, is that Lord Justice Fry, or in 1883, was on to something when he said it wasn't just a throwaway remark, contempt or something else. And although we perhaps can't say today what the something else might be, you submit, as I understand it, and I see why, I'm not saying it's right, I've no idea, but you say there must be a capability of granting such an injunction to protect the integrity of the court's process, even if it doesn't amount to it.
Yes.
You say that should be, that's the law.
Yes.
Yeah, okay, well, just to be clear, because we have to decide that,
Yeah.
I think.
There was a point made that the facts in Line Mile were more serious than the present case. Is simply to make that is not a point that we accept. Miss Okunola did make threats of physical violence, and those are exhibited in the bundle, exhibited to Galani 5, at tab 17 of the supplemental bundle, page 455 of the bundle, 458 of the PDF.
Just once?
There were 3 emails on that occasion, if memory serves.
458 of the sub. Okay. Yep, keep going.
Now, my Lord Master of the Rolls said that we need to bring this into the 21st century, and again, I couldn't agree more. My learned friend, the advocate, took you to Casserly, in particular at paragraph 48, where the Lady Chief Justice sets out the test for when communication is grossly offensive. And having determined that it is a question of fact, to focus on whether the message goes beyond the limits of what is tolerable in our society. And then at 3, there's the crucial bit in my submission for these purposes. The answer to this, whether that threshold has been reached, must reflect society's fundamental values. And my lords, my lady, to say this, it's not only my submission, but my fervent hope that 21st century values do not consider conduct of the kind at issue here to be tolerable. And if this court is concerned that there will be an unmanageable number of applications of this kind, it would mean that it is concerned that it is indeed common for the process of litigation to be beset by, on its face, unlawful conduct directed at legal representatives. And if there is indeed concern that this is the case, in my submission, guidance to the effect that the court's inherent jurisdiction does extend to prohibiting such activities would be all the more necessary. Unless I can be of any further assistance.
No. Well, thank you very much.
I think 30 seconds, just on the mens rea point. But just to remind the court that the mens rea for contempt is that the act must have been deliberate. And that's the Jordan case, so there's no specific intent. So with regards to emails, providing that the email is sent deliberately, it might be not a problem in addition to the reason that my Lord Justice Warby mentioned.
Thank you. And that comes from Jordan at paragraph...
Jordan, in the discussion from paragraphs 41 to 52, and it's all in.
And
it's all in.
Mr. Loaf has submitted the contrary in his submissions, but
yes, I mean, I took it to you this
we've
morning.
got that in mind.
His
His argument was that's limited to its context.
No, that's certainly that is not the reading of Jordan, because there they were precisely determining that the person playing the music didn't have to intend that he interfered with the course of justice, merely that he intended to play the music.
yes. Okay. Well, Thank you to counsel and solicitors. Obviously, it's been an interesting and difficult case, and we will take time to consider our judgments. When we hand down a draft judgment, please use that draft judgment only for the purpose of correcting factual typographical errors. You will try to agree an order, which may or may not be possible, but submit your draft order. We will not give you a lengthy time for corrections and agreeing the order, particularly in this case, probably only 24 or 48 hours. But then we will give you more time to try and agree the order with Ms. Okunola, and if you can't, we will deal with it in the usual way on written submissions. Thank you very much.